Hello viewers, welcome to our immigration program, Immigration and You. I am your immigration attorney Michael Fulwani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael. Always a pleasure to be here.
Now, and that's a very quick announcement you want to make again for the Teaneck Film Festival.
Sure. The Teaneck International Film Festival is going to be, thank you for reminding me, is going to be held in November, early November. And it's held, of course, in Teaneck, New Jersey, for those of you who are in the vicinity. And we, the NPZ Law Group, Nachman Fulwani Zimochek Law Group, will be sponsoring the film Ram Leela, which is an excellent film, and we look forward to seeing you there.
It's a very sexy movie, by the way, so watch out.
Very sexy movie, right? And it's actually the Bollywood version of Romeo and Juliet. So for those of you who have not seen it, and for those of you who have already seen it, please come join us. It's going to be an excellent event, and the offerings of Bollywood movies has been increasing. Of course, the demand for it has been increasing each year. So we, of course, at NPZ Law Group are pleased to be able to have a part in that event.
And we must at this time also thank Mr. Naz of Eros International, who has been very kind to offer us every year movies for this festival.
Exactly, and I think that they may be having a representative who will be at the event.
Yeah,
There's going to be
Mr. Ken Naz may come. Right. He's invited, and if he comes in, he'll talk a few words about the movie.
Right, and what we usually do is we come to the movie and we speak a little bit about the film and tell people a little bit about how the film was done, a little bit about the actors and actresses, and so it's our hope that he'll be joining us.
See, a lot of these movies, Bollywood movies, are like they have some Indian culture into that. Right. So for the American audience, like even Ram Leela, we talk about how the two dynasties they work and what happens in those kind of situations. Little bit of background so that when they start watching the movie, they'll understand why they are doing this or what they are doing there.
Exactly. So join us for this unique cultural event.
Okay. Now let's go back to last program. We talked something about administrative changes President Obama can do without going to the Congress, because anything that requires the change of the law, that only can be done by the Congress, not the President himself. But executive powers he has under which he can bypass certain things. So assuming, as we were talking in the last program, this may happen after let's say November, December, before the New Year. That's the word now. Before the New Year, before 31st December, these will go into effect. That is the last final promise. He has broken so many promises. I hope he doesn't break this time. But what we wanted to talk about is, assuming that happens, most likely going to happen, what are they talking about? What are they saying? What kind of changes can take place in the administrative process?
So what I'll do, Michael, is I'll lay out each one of them, and then what we'll do is we'll discuss them. But I think that the most important thing and the most interesting part of this is that we're talking about expanding these factors because these factors are already in existence.
Yes.
So
otherwise they couldn't be. If they're not there, then
exactly. In other words, that they're already there. Yeah. They haven't been challenged, or at least they haven't been formally challenged. Yeah. But they are already there. Yeah. So number one is expanding deferred action. So that's number one. So Michael, what is deferred action? Can you just tell us a little bit about that?
This is one of the memorandums on administrative processing that President Obama had announced earlier, in which it said that children who were under the age of 16 when they came to United States, and then they went to school, and they are not over 31 years of age, can be granted a deferred deportation. It's not a green card. It's not a permanent legal status. That existing law is already there. Deferred deportation, which was rarely which was rarely used before. I mean, I had a case long time ago where a child had a hole in the heart, and they were in deportation proceedings. But it is a humanitarian thing. We applied for a deferred action, and they granted that. And once they granted the deferred action, they also gave them a permission to work and stay until a final determination is made.
Exactly.
No, President Obama takes that that regulation, that law, and he came with this, that he believes that all these little children who came under the age of 1 year old, 2 years old, not their fault, the parents, many years ago. And they have been grown up like American citizens only.
Right.
They don't even know what is
16 years old,
legal.
right.
How can a parent tell me you are illegal? What do you mean illegal? I'm an American citizen.
Right.
So he says, I believe that they do fall within this provision.
Correct.
And he said, okay, anybody can apply for a DACA, we call it,
Deferred action for
deferred action.
childhood arrivals, right.
And then they can stay here, they can be granted permission to work, and then some of them can give driver's license also.
Exactly.
And quite a number, I think about 500,000 or 600,000 people got, or maybe more, under this program.
It's about 500,000.
Yeah.
Exactly.
Yeah,
And mostly from South,
So-
mostly from South and Central America.
Now we're
right.
talking about this thing that Obama did
Expanding
mention.
it.
Expanding, but
it,
expanding.
yeah.
This one, I think, is too much of expansion. I think the presumption is, or feeling is, that he may say, okay, all the illegal aliens who are here, anybody who is here in the United States can be granted, but which is very doubtful. But the second part of which says that parents of US citizens, that may more likely happen, because here we are talking 11 million and against 2 or 3 million. Right. So that provision, I have a feeling that parents or little children are born here. They came a few years ago, 1, 2 child are their citizens, even 2 year, 5 year, 10 year old. Their parents can get the same DACA kind of deferred action.
Yeah, and I think a lot of people, our viewers, probably don't even realize that you can make an affirmative claim for deferred action directly to the USCIS, because most people don't do it. It's almost like a thing of last resort. But if you feel that you have the equities, and I think that Michael pointed out the equities when he mentioned something humanitarian. So let's say you have an individual in the family who is extremely sick, and you have a need to stay in the United States to care for that individual, or that individual can travel, you can make out a claim for deferred action. It's an affirmative application that's submitted directly to the district director in the district with jurisdiction over where you live. And it's not a hard application to make. Of course, it's recommended that you utilize competent legal counsel to guide you on how to best present your case. But once that's presented, there is an opportunity for the district director to grant or not grant that benefit. So a lot of people don't even realize that there's an affirmative opportunity.
But the difference is this. Today, in the absence of such any administrative memo or anything, person really has to put in a lot of documents and information to satisfy.
Big equities.
Big equities.
Sure, of course.
But if he makes a policy decision that all the parents of US citizen children can be covered in DACA,
exactly.
It will open up wider and without any problems. All they have to prove that I have a child who's born a US citizen. So there's a
exactly, and that's, I think Michael's actually hitting exactly on what the new, the concept of doing something administratively. What he's talking about is taking a program that already exists and honing it to very specific criteria to say, these are the criteria that you have to meet. So as I mentioned, deferred action is something that anyone can try to get. The problem is that it's very subjective.
Yes.
So the criteria are spinning around out there, and you got to kind of grab onto it.
You're not sure whether there'll be
You don't know, right? You don't know if it's going to happen or not.
Yes.
But the difference is that if the president says, okay, here are the criteria, which is exactly what he did in DACA. He said, these are the criteria.
Exactly.
And they laid out the 5 or 6 criteria. If you meet those criteria, you're in. If you don't meet the criteria, you're out. Let's talk about another form of relief. It was done administratively. It's called Parole-In-Place. It was done for anyone who in their family has someone from the military, veterans. If you have someone in your family who is in the military, you can utilize, if you don't have status, this Parole-In-Place. And Parole-In-Place is another form of administrative relief that can be applied for affirmatively. So,
by the way, today we are doing this program is 9/11.
Yes, that's correct.
That reminds us that the victims of 9/11, the family members of those who died in 9/11, the immigration law was changed to accommodate.
That's right.
A lot of these people, the wife, children, all family members.
That's right.
So this shows that depending on the circumstances, the Congress could move, or the president can do that.
Well, I actually believe that when that happened, that was regulatory.
Yes, it was.
And I believe that Congress passed it because that's an easy political decision for Congress to make. That's where Congress easily could shake hands across the aisle.
I don't think single person opposed
exactly, of course. Yeah, I mean the benefits.
If you would have opposed that, he would have never won the election next time.
I only wish that it could be the same way for all the others.
That's why I mentioned. Let's talk about another important thing, which is the counting. You know, like
exactly.
See, you see the cutoff dates, as we say.
So this is another factor toward administrative.
Let me introduce a subject, as we mentioned before. Certain countries, right, who are current, AB2, for example, is current for most of the countries. India gets cutoff date because of the quota problem is their per country limit. So that is one of the issues also that I don't know whether that may need a congressional action or administratively that can be done. That is one way to increase the quota, increase the number.
That's right.
The other way is counting the family members, they call it derivatives.
Right.
So listen, if a person is applying, if a husband is applying for a green card, he has a wife and 3 children. So they count five visa numbers. But if the law changes or the President Obama makes the determination to enforce that provision that we talked about, then they will count only 1.
That's right.
Now, what will happen if you
have a larger pool of visas.
You count only 1?
Exactly. You have a much larger pool of visas that are available.
That raises to another issue. How long can they go back? Or it can be only...
Yeah, that's an interesting question, Michael, is whether or not there's going to be retroactivity. And I don't believe you're going to get retroactivity on something like that. But, of course, that all depends upon what ultimately is said. You know, so... Yeah, but usually that's prospective in nature.
3 years of retroactivity and all. But even that doesn't happen, even does not happen, believe me, the right away from the time this year onwards, 2000, from October onwards, that would make a big difference. I mean, this EB2 could become current. A lot of these categories even become current with the number of family members they are using. It's maybe more than the numbers. No, right now, each person is a family, wife or children, and there may be 3, 4, 3, 4, 2, 3. It will increase the number at least 3 to 4 times from what it is today.
Exactly, which is exactly what we need, because that would at least put the number of visas that are available over October 1st, which right now we don't even see that that's happening. So, and let's talk about the third affirmative action or the administrative action that the president can take, and that is a very, very important issue in the law, which we deal with on a day-to-day basis, is the definition of extreme hardship. And we deal with the definition of extreme hardship in the context of provisional waivers. And if the government were to liberalize the definition of extreme hardship, that would also offer an excellent opportunity for individuals to get benefits. And the president can easily do that without congressional support. So that's another way in which we can see some administrative movement. So, so with that, I know that, Michael, we're running short on time.
How about supposing President Obama likes you and me, and he says, blanket, okay, since you guys have done such a good job, wonderful programs on the TV and educating people, you have a blanket quota of 1,000 green card and 1,000 to me that you want to give anybody, you can do that. How's that?
Works for me. Actually, I was sitting down last night and I was thinking to myself, what works in terms of, what works in terms of what the president can do? And in addition to coming with these factors that we obviously just discussed, what about another 245I program? The 245I program is tried and true. It happened back in 2001, and it's given an opportunity for many, many people who we see on a day-to-day basis the opportunity to get their green cards because they have filed I-140s, I-130s, or PERM applications. At that time, they weren't PERMs. They were called ETA 750s, but they did it before April 30th of 2001. So they have a unique opportunity to be able to get their status in the future and to regularize their status here in the United States. So what about 245I?
They cannot, that's a law, a statute. 245I has to be done by the Congress. Administratively, I don't think he can change 245I. That's a
Well, but
there.
I'm saying in terms of programs to fix the situation.
it, yeah,
So
fix
that one is tried and true. Why can't he try to get Congress to shake hands over the aisle over a new 245I program? It
Right.
seems to me that if you are going to get Congress to shake hands, that might be a perfect program to shake hands over, since it's tried
we
and
shake
true.
hands. There are a lot more things to happen. You know,
course.
Look at the CIR. You got hundreds of good new categories, increase in the quotas, even changes in the waiver program. I mean, right now, you know, the 212 is 60. Some people are denied because of fraud, misrepresentation. They used to have qualifying relatives, spouse, parent, or a child. They changed the law. They took the child out of it.
Right.
So now somebody to get a waiver of the charge of ineligibility under fraud or misrepresentation, they have to either a wife,
Higher burden.
husband, or a parent.
Exactly.
Now, they could easily go back because that's, in my personal opinion, the inclusion of children was a good provision. It was only fair and only right thing to do. And, you know, they changed this. I don't know what were the reasons for that. Always there's a problem between the politician. It's another political issue.
Exactly. I think we're running short on time, Michael. So with that, maybe we'll come back and discuss some questions that our viewers have in the next
again,
program.
this time, the time goes very fast, and we, of course, when we talk, we get also more and more interested. People are enjoying. I know they are finding our programs very helpful and useful. So thank you for watching our program. David, thank you for being
Always a pleasure,
here in the
Michael.
program. And you please keep watching us every Saturday and Sunday at 11:45 a.m. Thank you.